Thanks and welcome to you both to the committee. I'm sorry we're so far apart and spread out here. That's the nature of the pandemic. Usually it's a setting in which we can see one another a little bit better. I wanted to ask you both questions about fact-finding at the appellate level. We had an interesting hearing in my court's subcommittee yesterday on this very question. It was my training in law school, my training when mentored by experienced appellate advocates, and my mentoring when I was trying to bring along other appellate advocates to stay the hell away from the facts. Because really the only two ways that an appellate court gets to look at facts is either to be asked to overturn a factual determination by the court below, which is heavily defended by the clearly erroneous standard, and therefore not usually a great avenue for appellate advocacy, or facts that are really not in dispute, facts of which judicial notice can be taken, that Christmas fell on a Wednesday in a particular year or whatever. What are your thoughts about the role of appellate courts engaging in fact-finding that is outside of the record that's presented to the court, either by Congress as it put together the statute that is the subject of the challenge, or by the court below as it assembled the record to support its decision? What, as an appellate judge, do you get to do at that point regarding facts?
Well, thank you, Senator, for that question. Let me just say that my training was similar to yours in terms of the judges for whom I clerked at the appellate level and the way in which at least I was taught to think about the role of the appellate court in terms of the facts. I don't, as I sit here, know what the practice is in the District of Columbia, and I will say that we have a little bit of an unusual docket insofar as so many of our cases come through the administrative process, where even at the district court level, we're not looking at trials very much, and we're not developing a factual record very much. There is already an administrative record that travels with the case. So I think, I would have to...
Let's say whether it's a congressional record or whether it's an administrative agency record or whether it's a trial court record, those are three sources that a appellate court can draw from to determine what the facts are in the case and to support or overrule the finding of the district court. What happens when a court goes outside those records and starts finding facts on its own, sua sponte?
Yes, I frankly don't know. I would have to talk with my colleagues and look at the federal rules of appellate procedure and the practices, local rules of our court. I'm not sure the circumstance in which the appellate court would feel at liberty to do that sort of thing.
Okay.
Yes, Senator. Broadly speaking, Senator Whitehouse, federal courts are courts of limited power. And one duty of circuit court judges, and I remember this very clearly from my time clerking on the Fourth Circuit Court of Appeals, is to be quite restrained. Federal judges are supposed to be restrained and decide only the issues that appear before them and no other issues. It extends in the way you described to fact-finding. So it would be, from my experience, both clerking and then also litigating before the Seventh Circuit Court of Appeals, quite rare for appellate judges to go outside the record. And I sitting here today, I can't tell you a circumstance where I've seen it. in my own practice, so I can't tell you what exceptions there might be to make that rare thing happen.
Yeah, the case that obviously comes to mind that has enormous impact on those of us in the political line of work is Citizens United, which allowed unlimited amounts of money into politics on the premise that all of that spending was going to be transparent and therefore would not contribute to corruption or the appearance of corruption of the political system. And of course, it's indisputable that it has been anything but transparent. We're well through $1 billion in anonymous political funding. So that fact that Justice Kennedy stood his decision on is simply provably false, which then raises the question, now what do you do about that decision? If that fact was the hinge upon which the decision swung, and the fact is false, where do you go?
Well, Senator, for lower court judges, we can't go anywhere, really.
Yeah, even when it's fact-finding. I mean, you're supposed to agree with the legal determinations of the Supreme Court and to follow them, but it's an interesting question whether a false factual determination by the Supreme Court merits similar deference or the deference that separation of powers puts the legislative and executive branches under with respect to a Supreme Court decision. It's something to ponder because it has not been the custom of the court to engage in this free-range fact-finding, and particularly false free-range fact-finding, but some of the political decisions of the court have stood on false free-range fact-finding, and it raises this whole new interesting set of questions about what do you do when the Supreme Court has made a factual determination that is not supported by any record, that is provably false, that is essential to the logic of their decision. Is it really true that all of government is powerless to address that error? So I have used my time, something for you to ponder as you move towards your seats on our circuit courts of appeal, which I will strongly support. Thank you.
Thank you.